Welcome to the Alberta Prosperity Project Podcast. If you're ready to listen, sit back, relax, and enjoy the show. Thursday, July 28th, 2022. Welcome to episode 12 of the Alberta Prosperity Project Podcast. I'm your host, Hunter, today, joined today with Tanner, who is actually up north, and Dr. Michael Wagner. How's it going to both of you?
I'm doing excellent. Fantastic.
Yeah, yep, things are okay for me too. So
lovely. We've been up speaking with the APP up north in Peace River, and it's been so much fun. Yesterday, I got to take the ferry across the Peace River for the first time ever, and that was an adventure. Let me tell you, lots of fun. The scenery up here is gorgeous. The north is some of the nicest scenery, I think, in Canada. It's just stunning. And then we're heading up to La Creek today, actually, all the way up, way up to have a massive event up at the Heritage Center. So that'll be a lot of fun. We're excited.
Yeah, absolutely. And obviously, as the people that are watching the video can see and those listening, we do have a special guest with us this week, and that is Dr. Michael Wagner, who you may have seen him at some of our events, or you may have read a couple of his books. The No Other Option is definitely one that often people talk about to us here at the APP, and Alberta Separatism Then and Now, which we might talk a little bit about, Dr. Wagner. But just to start off with, can you maybe give the listeners a little bit of a brief overview on your background and your history with the Alberta Independence?
Sure. Just a little bit of background. I basically grew up in Calgary. I did almost all my schooling in Calgary, and I got a BA and MA at the University of Calgary, and then I came to Edmonton to get a PhD at the University of Alberta. That was all in political science, but in graduate school, actually, my area of expertise was education policy. I was very concerned about educational choice and parental rights and things like that. So that was kind of research I did back then. But personally, back as long ago as back when I was a teenager, I first got involved in the Alberta independence movement. That was like during the first wave of the movement in the early 80s. I'd been a little bit interested in politics with my friends, at that time, mostly in international politics, but it was the National Energy Program and the uproar that resulted from that drew me, gave me an interest in Alberta politics and Canadian politics. So at 15, I joined my first political group. It was called WestFed. And then when I was 16, I joined the Western Canada Concept Party of Alberta, which had just elected a member in a by-election in Olds Didsbury in 1982. And there was a lot of excitement in those days. That was very exciting, to have an elected member. So back from then, I remained somewhat involved in that movement during, early to mid 80s. It started to peter out, I guess, toward the late 80s because of the rise of the Reform Party. And that was, the Reform Party absorbed basically all of the Western activists. And so the Western Canada Concept Party folded back then, at that time, because basically everybody was absorbed into the Reform Party. It was the going thing. So eventually, though, doing other research, I would come across some old historical materials on the Alberta independence movement as I was researching in the 90s and later. And so I realized, somebody should write a book on the history of the Alberta independence movement. And it should be written from the perspective of someone who really understood the movement from the inside, because there was a lot of outsiders who were critical of the movement and had all kinds of nasty things, some of it untrue, that would say things about that. And I thought, well, if I write it from the perspective of someone who participated, the real motivation, the real incentive, the real what was really involved would come through. And that's how I ended up writing Alberta Separatism Then and Now. I completed that in 2009. The interesting thing, though, interesting in a sad way, when the book came out, there was no interest in it whatsoever. And the sales were so small that the publisher actually pulled it, and it wasn't even available for years. And then when 2015 rolled around, Justin Trudeau was leader of the Liberal Party, and I contacted the publisher and I said, if Justin Trudeau was to become prime minister again, there's going to be a market for this book. So essentially, when Justin Trudeau was elected in 2015, that's why the publisher brought back the book, because now there would be a market for it. It took a little while to develop, but I'm really pleased. I guess during 2019, with the formation of the Wexit movement and then the re-election of Trudeau in 2019, that created interest in the books, and I was able to sell some at the Wexit meetings and things. So it took more than 10 years for any interest in that book to develop, but it developed right out of my personal participation in the movement in the early 1980s. It was something that was dear to me personally. So that's a little bit of a background on how I ended up writing that particular book. Now, basically, after I finished university, I didn't go into academia. Started working for a friend who had a small niche market publishing company. But eventually I started doing writing on the side, first articles, and then I had time to write books. And so my first book was actually on the history of Christian political activism in Canada. And then I did the Alberta Separatism Then and Now. And then I've done others since then, like a critique of the Charter of Rights. But that's kind of how the writing developed. It was something I did on the side. It wasn't like my career. I just worked in, basically in a publishing company for a while, and then more recently for a schooling organization. So the writing and that kind of stuff was more of a hobby than any part of my actual career. So that's a bit of my background anyway. Hopefully that's a little bit helpful.
Yeah, absolutely. Definitely nice to hear about the book sales picking up. I definitely can't foresee why that might be the case. But no, of course, we've talked about on the podcast why that would be. But I guess then moving right into the episode. So for those that don't know, obviously now you've mentioned you have this great length of history within this movement and within these scenes. And so something that we hear often at Alberta Prosperity Project events and from a lot of Albertans, and I think rightfully so, is concerns about the Clarity Act and what it actually is and what it says and does it apply to us even, or how do we navigate this? So could you maybe just touch briefly just on what actually the Clarity Act is and whether that might be an issue for Alberta independence?
Sure. Well, like the background to the Clarity Act is actually the secession reference case of 1998. Now that arose, you will probably remember, at least some of the people will remember, in 1995, Quebec had an independence referendum that almost succeeded. It was just barely defeated. Mm-hmm. Now, because of that, there was questions about the constitutionality of provincial independence. Like nobody knew if that was actually in the Constitution or not. So the Prime Minister, the federal government, asked a specific question of the Supreme Court of Canada. It's called a reference case. The federal government and provincial governments can ask reference questions, like when there's not a court case on a specific issue and they still need an answer on a particular constitutional question, they can just ask that question to the Supreme Court and get an official ruling. So the federal government asked the Supreme Court, could Quebec unilaterally declare independence after a referendum? Because that's actually what had been the issue in 1995, because Quebec was having that referendum. So could they do that unilaterally? And the court ruled, no, they cannot declare independence unilaterally. That's not part of Canada's constitutional law. However, and this is a big however, if they hold a referendum on independence with a clear question and there's a clear majority in favor of independence, then the federal government has an obligation to negotiate that province's independence. Now, the idea of the clear question, that arose because in the 1995 referendum, and of course there had been a 1980 referendum as well that failed, the questions were not entirely clear. Like people interpreted it as for or against independence, but I don't have the questions before me, but I heard them at the time, and they did have the propensity, like someone could read that and not really have an understanding of what the question was about. And so I think the court was very wise to make sure it's a clear question so that there's no misunderstanding when someone's voting yes or no. Like the Quebec's question might have been something along the lines of, and I'm just going by memory here, do you give the Quebec government the right to renegotiate Quebec's relationship with Canada, or something like that, which from the perspective of the people involved implied independence, but it could be read as not necessarily meaning that. So someone could vote in favor of that without necessarily meaning independence. So it's very important that the question be clear. And also then there is the issue of, like, if someone voted in favor, like in Quebec, the separatists figured that 50% plus one was enough to declare independence. Well, there is a question, like a long historical question in different areas of political science, is 50% plus one a sufficient majority for a major constitutional change? Like, I mean, when we're talking about legislation, just basic bills, tax levels, energy policies and stuff, 50% plus one, that's just a basic democratic principle, because laws can be changed from one parliament to the next. It's not a big deal. But when you're making a fundamental constitutional change, 50% plus one, really doesn't cut it, because that could just show a temporary view in the population, like maybe 50% plus one favors this today, but a few months from now they might have changed their mind. You know what I mean? Because when you look at polls, people's views on things are changing all the time. So if you're going to make a fundamental change to a constitution, it should be more than 50% plus one, because you're making, you can't just change constitution and then change it back when it goes to 50% minus one. You know what I mean?
Right.
So you want what's called usually a supermajority, and so that's why for example, currently Canada's constitutional amendment process requires 7 of the 10 provinces representing at least 50% of the population. Now, that may be a good or bad amending formula. I'm not saying whether it's good or bad. I'm just saying it's the principle that you need a bigger than normal majority to be able to change the Constitution. I mean, it's the same in the United States. I think the United States Constitution requires like 3/4 of the states to approve a constitutional change, as well as the Senate and the House of Representatives. So Canada is similar in principle, but the idea is if you're going to make a fundamental change to the way a country is structured, you need more than just a bare majority. You need like a substantial majority or a clear majority, to use the terminology of the Supreme Court. Now, people could disagree on what counts as a clear majority. Maybe some people might think 55% or 60%. That's a different debate. And part of actually one of the good things about the Clarity Act, or one of the wise things about it, is it does the Clarity Act is actually the legislative component of the secession reference case. I didn't say this earlier, but I should have. The Supreme Court, when they made the secession reference decision, they gave their basic principles. The basic principle is a clear question with a clear majority, but those are basic principles. Now, someone has to kind of determine what exactly the clear questions, like someone has to say what is a clear question, and someone has to determine what the clear majority is. And so that kind of was turned over to the House of Commons, or the Parliament. And so the Clarity Act is kind of the fleshing out of the secession reference case in a legislative fashion. Now, the good thing about that is, I mean, you do need something like that. You need to be able to determine what the clear majority is and whether something's a clear question. However, there's a lot of concern, like, for example, among Quebec scholars, that the Clarity Act actually is tighter than it needs to be. Like, it makes the process of becoming independent more difficult than it needs to be, or at least potentially throws up hurdles that probably shouldn't be there. So that's kind of the concern with the Clarity Act, and people are rightfully concerned that we've seen people like Justin Trudeau don't always follow the letter of the law or even the spirit of the law. And so what if he wants to use the Clarity Act as an obstacle, rather than the avenue that it's supposed to be? And, that's a legitimate concern, but like, I'm not personally really concerned about that. Like, one of the reasons is because the secession reference case was actually considered to be a gift to Quebec. Like, it was Quebec nationalists who were pursuing independence. And so when the Supreme Court, when it's making these political decisions, wants to give a little bit to each side, they're very political that way. They're supposed to be just constitutional and legal, but they do see which way the wind's blowing. And they wanted to give the federal government something, and they wanted to give the Quebec nationalists something. So they gave the federal government the decision that there's no unilateral declaration of independence, but they did give the Quebec nationalists this other avenue that's to pursue. So it's kind of, it was very much a Quebec decision. I mean, when you read the decision, it's referring to Quebec in particular, even though it does apply to all provinces, because Quebec is just one of the provinces, but it's very much applied to Quebec. And so it did give this avenue to Quebec. Now, if Justin Trudeau or his government tries to prevent Alberta from following that path, he's actually symbolically taking away something that was given to Quebec. And so there would be definitely people in Quebec who would be concerned if the Clarity Act is being used as an obstacle rather than as a clarification as to how a province should get out. So so on the one hand, there are legitimate concerns, but on the other hand, there are the other considerations. And also too, if let's say Alberta holds a referendum and there's a clear question and a clear majority, other countries in the world will be paying attention to that, and especially the United States. We've had good relations with the United States. It would look very bad for a federal government in Canada to declare that a democratically, that a referendum that followed the law and followed the Constitution is now going to be declared null or void, or at least nullified in terms of practice. That's not how any democratic government is supposed to operate, and that would raise concerns in other countries and perhaps the United States. So those are two of the reasons why I don't think should be really a concern. Like, I do think that the principles laid out by the Supreme Court. I should also add that there, like, these scholars I mentioned in Quebec who think that the Clarity Act is too tight. Some of them have written, that fundamentally, and this is true when it comes to the Supreme Court's decision, fundamentally, it's the clear majority with a clear question. That is the democratic mandate. That has the legitimacy. That has more legitimacy than any kind of obstacle that the federal government could throw up. And so there are scholars, and actually I quote one particular scholar in No Other Option saying, if the federal government tries to use the Clarity Act to block, and he's talking about the Quebec context, if they use the Clarity Act to block Quebec's independence when Quebec has voted, in favor of independence, it won't work because Quebec will become independent. So fundamentally, if Albertans really supported independence, with a strong majority, and were willing to pursue that, I do believe that would happen. One other thing, though, I think I should throw in here, I don't think the Clarity Act will be the problem. Like, when Alberta starts to move towards independence, there's a different thing I've thought of that is more likely to be our problem, and that is that, let's say we get a provincial provincial government that is sympathetic to independence, that gets elected and is willing to hold a referendum, I think what you'll start to see is suddenly rhetoric in Ottawa will change, and suddenly you'll get all this lovey-dovey rhetoric about Alberta. Oh, we so love Alberta, and suddenly Alberta businesses will be getting government contracts, and Alberta communities will be getting grants for new community centers, and Alberta First Nations will be getting their water systems fixed and new housing. If you know what I mean, like suddenly all these kind of soft things will come in, and this will sway a certain percentage of the population. See, that's the advantage that the federal government has, is like, we need to get a clear majority. All the federal government has to do is undermine the clear majority, and money has a tendency to do that. And the Liberals have a history of throwing money at problems, right? So it would be much wiser for them. Like if a provincial government was to be elected in favor of holding a referendum, it would be much wiser for the federal government, and cheaper in the long run, to just start sending love our way. And this, not just verbally, but when businesses start to get federal government contracts, that'll sway some people, and communities getting new hockey rinks, and you know what I mean. I mean, it's inevitable. It's a human nature thing. It's not that there's anything wrong about people. This is just the way it goes. So I think that would be the smarter way for the federal government, and also an easier way for the federal government. And so it's like using the carrot rather than the stick. And they can gain more with the carrot and the stick. And they wouldn't have to do that for very long, right? They don't have to do that for maybe a couple of years until the threat of this government passes, and then it can go to status quo ante, back to the way it was before. But in the meantime, without any of the complex problems of the Clarity Act and so on, or international relations, they would be able to come in that way. So I think that that's kind of more likely to be the threat that we'll face, rather than more political obstacles. So anyway, I hope I've gotten around to the main idea of your question there.
Absolutely. Yeah, no, that I think answered all the concerns that I think, or a vast majority of the concerns that we often hear. And I like the example, and that kind of ties in maybe nicely just to the next question that I'm going to ask. And that's kind of why would the Sovereignty Act maybe not be enough? Like, why is independence, the goal that you've been working towards and all of us have been working towards? Like, what is, why not just stay within Canada is often a question we get too.
Right. Sorry, I might just jump in. Right. Especially considering, I think your point is precisely correct, that you'll have the federal government, once they recognize that this is a legitimate movement, throwing all of these, benefits and desserts, so to say, to Albertans to try and sweeten the deal in Confederation. So, having that in mind, would a Sovereignty Act alone then be enough? Would it be enough to show the federal government that we're serious, and as such, start playing our game kind of thing? Or is it still insufficient?
Like, I think it's insufficient in the long run. Like, there are very good things about the Sovereignty Act, and I don't want to, I don't want to hammer it per se. Like, I think it's not the best route. Like, I think the APP has a better route forward. But that said, the Sovereignty Act has good things to it. I just wanted to raise one thing. Can I just show you a newspaper article here? This is actually Barry Cooper, who's one of the authors of the Sovereignty Act with the Free Alberta Project. Okay, this is from the National Post in June, and it's a column by Barry Cooper saying the Alberta Act unconstitutional by design, because one of the main features of the Sovereignty Act, as Barry Cooper states it, is to provoke a constitutional crisis. Because their goal, like you mentioned, the Free Alberta strategy is to keep Alberta in Canada. But they know that, and as Barry Cooper says so well in this article, we cannot have the status quo. The status quo is completely unacceptable, and they recognize that and they acknowledge that. So their point, or their goal with the Sovereignty Act, provoke a constitutional crisis by doing things that are unconstitutional. Now, in and of itself, like that's not necessarily a bad thing. The problem is, and actually Dr. Modry has pointed this out, that a constitutional crisis will ultimately have to be settled by the Supreme Court. The Supreme Court has 9 justices. 7 of them are from Eastern Canada. So in one sense, I can see the constitutional crisis potentially being beneficial for Alberta. But if it does go to the Supreme Court, I don't think Alberta's chances are really good, if you know what I mean. But I mean, the people in the Free Alberta strategy they're some of the smartest people, Rob Anderson and Barry Cooper and stuff. And I don't want to be speaking against their thing, but their goal is to deliberately be unconstitutional as a way of provoking a crisis. And I see the reasoning in that. It's not a bad form of reasoning. Like, it makes sense. However, doing it that way, provoking a constitutional crisis, there's all kinds of things we cannot predict. We can't predict what the crisis will be over. We can't predict, how the federal government or other provinces are going to react. There's lots of unpredictable things in there, kind of unknowns, right? There's unknowns. The APP approach with the referendum, it's constitutional. We know that from Supreme Court. It's even, in legislation in the Clarity Act. there's no confusion there. There's it's no opaqueness. Like, it's clear, it's accepted, and it's easy to understand. I guess that's the other point. The APP approach with the referendum, it's easy to explain to people. Let's hold a referendum on independence, yes or no.
Yeah.
The Sovereignty Act it's not that easy to explain. Like, even though it's a good idea in many respects, like, how do you explain it? Well, we're going to provoke a constitutional crisis. Well, over what? And who's gonna, what I mean? It's just like, it's not that I dislike the Sovereignty Act per se, but I couldn't fully explain all the implications and things, because I'm not sure that we really know what those implications are. So just to summarize, the APP approach is simple and easy to explain, and it's constitutional. That, for me, like, that's a sell. You know what I mean?
Right.
The Sovereignty Act is it's more difficult to explain, and it's not constitutional. And so like I say, I can understand why people would want the Sovereignty Act, especially for those who have an emotional attachment to Canada and want to stay in. But just like, I mean, of course, I'm biased because I've wanted independence for a long time. So, and the APP is more that direction. But still, from these two other perspectives, it's still easier to explain and to understand the APP approach, and it has less unknowns. Right. They're less. So the unknowns are people like questioning, the Clarity Act. Would that be an obstacle? Well, that kind of, like, if the government follows the proper rules, it won't be. But I mean, you can't predict what people are going to do, right? But just with what we can know, the APP approach seems clear and open compared to the Sovereignty Act approach.
Hunter, maybe we could ask the last question and just and tie it all together. Well, maybe you ask it, because you're a better questioner than I am. This isn't my forte.
No, that's he's usually the one answering them. For those that haven't listened before, that's the usual way that it goes. But I guess when we're looking at this now on a broad scheme of things, with the courts and with the charter, I know that you touched a little bit on mentioning the charter before also, but does the charter kind of tie us to Canada in a way that it makes it actually kind of impossible for us ever to actually gain our independence? Like, are we stuck where we are? We can't ever really get over this constitutional amendment. There's no hope for Alberta, or do you maybe see that hope for us?
And maybe what's your opinion of the charter as well? I'd be very fascinated to hear what you think.
Well, actually, like, I'll answer the first one. Is more brief, and basically the charter is just one part of the Constitution. So the secession reference case applies to the charter just as much as anything else. Like, the secession reference case is an explanation of Canada's constitutional law. So it's not it cannot be overpowered or by the charter in any way. So the charter is just another part of the Constitution. Now, I'm glad that Tanner asked me that question. I'm a critic of the charter. I don't think it's a good thing. I mean, remember who was the number one person pushing the charter from the late 60s until it was adopted? Pierre Trudeau. Now, is Pierre Trudeau someone whose policies we like? Someone whose political philosophy we like? No. So there's so many people who I know do not like Pierre Trudeau, but they think the charter is a good thing, and it doesn't make sense to me. Trudeau had a particular agenda with the charter. Trudeau did not like Canada. Like, when he became involved in politics in the 60s, he did not like Canada the way it was. He wanted to fundamentally change that. And how do you fundamentally change a country? The best way is to fundamentally change its constitution, and that was his goal right from the start. So, as he was, I think he was justice minister when he first announced his intention his desire to have the Charter of Rights and Freedoms, and so it was debated, from the late 60s right through the 70s, because he became prime minister, of course, and there were lots of constitutional discussions going on, because many Canadians, the Canada's constitution at that time was the British North America Act, which was simply a piece of British legislation, and many Canadians felt, we need to have a constitution fundamentally based in Canada, not based in London, England, and that makes sense, right? We're our own country. So there was a big majority supporting what was called repatriating the Constitution from Britain. The problem was there's two main problems. One was if we got it back from Britain, we'd have to have a way of amending it ourselves, and Quebec wanted a constitutional veto, and Ontario might have wanted one too. I can't remember. So the provinces could not agree on an amending formula. And actually, just to throw in a footnote here, the amending formula we ended up getting was actually Alberta's amending formula. It was Peter Lougheed, and even though it's a tough amending formula, the amending formula we have does not formally recognize a Quebec veto or an Ontario veto. I mean, in effect, there might, it almost goes that way because they have so much population. But Alberta did get this principle. The principle in the amending formula is provincial equality, because it does not state that any particular province has more weight than the others in the constitutional winning formula. So anyway, that's kind of going on a rabbit trail. But Pierre Trudeau wanted to fundamentally change Canada, and he eventually, through the constitutional negotiations, especially in 1981, he was able to get that charter added to the country, or added to the Constitution, which did fundamentally change Canada. And another interesting historical fact I might mention is back in those days in the early 80s with the Alberta separatist movement, one of the main intellectual leaders of the separatist movement was a woman named Ruth Gorman, Dr. Ruth Gorman. She was a civil rights lawyer. She had won in the late 60s. She won an award called Alberta's Woman of the Century. She was very distinguished, very well respected, and she became part of the Western Canada concept of Alberta. In fact, I think she was one of the founding members, and she was so opposed to the charter. That was her main beef. She thought Trudeau's charter was going to, really harm our country. Now, her angle on it was the lack of property rights. She really feared that, because we'd always had those property rights, and it was a deliberate choice of the Trudeau Liberals not to have property rights in the charter, and she saw that as an avenue that they would use, to violate our property rights. Well, that hasn't really, necessarily come to fruition the way she expected. But she was right, that the charter was not a good thing and would have harmful effects on Canada over time, which I agree with. And so actually, like as I mentioned, I've written a book called Leaving God Behind, where the charter was very much a secularization of Canada's constitution, and brought about fundamental changes that reduced the public presence of Christianity in Canada. Now, one of the main things and one of the deliberate intents of the charter was to transfer some political decision-making power from Parliament and the legislatures to the Supreme Court. Like, that was deliberate. I know a lot of people think that happened by accident. Like, a lot of people say, well, look at the judges, look at how they use the charter. And the judges do use the charter, and they do use it for their own preferences, and that's true as far as it goes. But in the debates in the 1970s, if you read the debates, the scholarly debates, there'll be hearings on it, and political scientists and law professors would come and testify saying, look, if you adopt this Charter of Rights, you will be giving the judges political power that they never had before, and they will start making political decisions that they didn't have before. And that's exactly what happened. So the people who were paying attention at that time knew that was going to happen. So we shouldn't be surprised, because that's what they were talking about. And I should add too that the charter, formally was adopted in 1982, but there was a 3-year grace period for much of it, because the provincial governments and the federal government needed 3 years to conform legislation to the charter before it came into force, or else there would be immediate court cases against all kinds of legislation. So they gave them this window of opportunity, make all these changes to make the laws in conformity with the charter so that we don't get them all challenged right away. So in 1985, the charter was coming into effect, and the justice minister at that time was John Crosbie. And he said publicly, the charter is a revolution. We've just had a revolution in Canada with the adoption of the charter. And he announced that publicly in 1985, and he was right. I mean, he was there. That was just at the very beginning, and we have seen a massive change in Canada. Now, Canada was already in a left-wing direction before the charter, but the charter gave left-wing groups, new political tools, very powerful constitutional tools to advance their agenda. And so their agenda got advanced more quickly and with more authority than it would have, had our constitution remained the way it was before. So I don't think the charter is a good thing. I mean, it's here right now. We're not getting rid of it anytime soon, except if Alberta was to become independent, we'd have an opportunity to write our own constitution, and so the charter wouldn't apply to us anymore. So I guess for those people like me who don't like the charter and realize that under the current circumstances it can't be changed realistically, having an independent Alberta would give an opportunity for a new start with a new constitution, and maybe we can do it right this time.
Perfect. Absolutely. And just before we wrap up the show, I know that you had mentioned before your books that you were talking about. Where can the listeners go find those books? Is there a place online where they can purchase those or get in contact with you? Do you have a site to go to, or what's best for that?
Actually, for most of them, the best site is it's a small Didsbury-based business, a homeschooling business, and it's online. It's called merchantship.ca. So just spell out merchantship.ca, and all the books I've mentioned are available there. The new one, No Other Option, is available there, but it's also available on amazon.ca. So can I just show that for a second?
Yeah, absolutely.
Okay, this is the most recent one.
There we go.
No Other Option. Okay, this one is available on amazon.ca as well as merchantship.ca, and the other ones are available on merchantship.ca. So it's just a small Alberta-based business. If you would like to support Alberta business, that's where to get it.
There we go. Hey, we're all about that at the APP, as I'm sure you know, and I will link that in the description below as well. So for those that are interested in that, be sure to go check them out. They are great reads, and definitely you can learn a lot more about this movement and the history of it. But with that said, that is all the time we've got today. So if you want to help support the project or the podcast, I I encourage you to go to our website as well. It's albertaprosperityproject.com. We'd love to see you in the events. Like Tanner said, he is up north. If you're in La Crete today, make sure to go see him. He'll be there tonight. Should be a great event there, and we're just looking forward to a great August and the rest of the year as well. So with that said, it was great talking to you there, Dr. Wagner and Tanner, and see you next week on the podcast.
Thanks so much for having me.
See ya.
Perfect. See ya.